What have we seen in the employment-based and immigration landscape in 2025, and what can we expect looking into 2026? That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I wanted to take these next 2 weeks, this week and next week, to kind of provide an overview of what we've seen, because it has been a lot, right? So what we've seen in the immigration landscape today, we are talking about the employment-based landscape. Next week's video will be on the family-based landscape. So if I had to summarize the immigration landscape in general in the United States, I would summarize it with the word uncertainty for 2025. And I know that's not very settling, but really that is what we have seen ourselves as immigration law professionals, and that's what our clients have felt certainly as well. I'm sure more than even we have as well. So even though we've seen uncertainty in 2025, and of course we can expect that to continue in 2026 in this very volatile, dynamic immigration environment, but what we can do is control what we can control, know what we can know. So let's take a minute to look back at what has happened in 2025, what we know has happened, what has realistically happened versus what the headlines have said, and what we can do to prepare for 2026 going forward. Keep in mind that there is hope. There always is hope. So before we get into the details here, keep in mind that this is not legal advice. This is for informational purposes only. And I'm not going to cover everything that happened. I'm not going to spend the rest of the day going live. And I'm sure you don't want to watch me for the rest of the day. So this will be just a high level overview of what's happened and really what's affected our clients and the types of cases that we handle here at Sumner Immigration Law. So the first thing is, in January 2025, there were new regulations that came out. They were actually set out by the Biden administration, so a previous administration, that was called, set of regulations is called the H-1B modernization rule. And it really wasn't as big of a deal as it sounds like, right? You think, oh, new H-1Bs new regulations for H-1Bs, what's happening, what's changing? Really, it was just putting into regulation, not entirely, but for the most part, it was putting into regulation form. So regulations are the rules that the agency creates and has to follow, and it's supposed to be based on statute. So really, it was putting into the regulation things that really we'd already knew about, we'd already been following. The agencies have already been doing, we as immigration law practitioners have already known about and have been advising our clients about. So it really wasn't anything groundbreaking. It was nice to have those in writing and to have it solidified and in the regulations. So that set of regulations was pretty extensive. So I'm not going to cover everything that was covered in those regulations, but it clarified the rules, the regulations clarified that, and again, this is something that we know, it's not groundbreaking, but that the word or the phrase specialty occupation means that the position has to be one that requires a degree in a directly related field of study. Again, this is not groundbreaking, but it's in the regulations. Now, it clarified H-1B cap exemption situations. I'm not going to go into detail there, but again, it was nice to have some clarity around that, some more expansive definitions there. It put into the regulation definition of employment and third-party work sites. The focus is on there being a true job offer, even if the position is actually at what's called a third-party work site. Again, something we've been dealing with for years now, but it's been put into the regulation. It did expand the authority for DHS for site visits, or at least put that into the regulations, and that's been a big theme that we've seen this year. Not necessarily in actuality. We've had some site visits. And of course, we saw in the news the Hyundai, I think it was Hyundai site visit, it was essentially a raid. But in any event, I've had lots of clients who have been concerned about site visits, understandably. I think that's rational. Anyway, it talked about when amended petitions are required, and it really put into the regulations what we've already been doing based on case law. And then a good thing is it expanded the H-1B cap gap to April 1st. That cap gap used to end on September 30th. Now it's been extended to April 1st. So we had that set of regulations, right, to start things off kind of on the right foot, more or less. And then the administration changed, right? And so then we had lots and lots of changes over the course of the subsequent months, as we all know. In terms of H-1B processing, we have seen internally, so we have that set of regulations, right, that came out in January, Otherwise, we have seen, we'll talk about travel in just a minute and visas, but really in terms of H-1Bs, the big thing that we have seen is, and it's not even huge, but a slight increase in the number of requests for evidence for specialty occupation. That means questioning USCIS, questioning whether the position is one that requires a bachelor's degree in a specific field of study. And we've seen some RFEs asking for original signatures. So this isn't anything new necessarily. It's just that we've seen a slight uptick, and it's not anything tremendous. It's not anything that's like, oh my gosh, every single H-1B that we're filing is getting this type of RFE, this type of request for evidence, but we've seen a slight uptick there. TN processing, knock on wood, has gone pretty smoothly. We did in our practice, and I've heard this somewhat from other immigration practitioners as well, we did have, and this is true not just for TNs, but for other visa classifications as well, we have had petitions denied, TN petitions denied, unfortunately just a couple, but we've had TN petitions denied that previously have been extended without issue a couple of times in the United States. So what my point is, just because you have a petition or application or petition, let's say, for an H-1B, a TN, an L, an E, whatever it is, just because you've had a petition approved previously does not mean that it will be approved going forward. And that's always been the case. It's just that we happen to see this. We happen to have that experience this particular year. Otherwise, TNs, we've had lots of TNs that have been processed out of Canada, at the border, at the port of entry, that have been processed just fine. We, of course, have to be strategic, make sure that all of the elements are there, but that's been going fine. TN processing in Mexico has been, I would say, difficult, tricky, inconsistent is probably the best word to describe it, really for the past several years. And that's what we're continuing to see in Mexico. So absolutely, we've had approvals. In fact, I don't think we had any denials. That's not a guarantee by any means. It's just what we've seen in this particular year. But we have, just in general, and we've seen inconsistency in the adjudication of TNs in Mexico for the past few years. So it's really important to be strategic, intentional, careful in how you present everything. EADs, employment authorization documents. So there have been several changes there to the employment authorization documents. Employment authorization documents are often called work permits, and they can be granted, they can be given to a person when they apply for a green card. They can be given to someone sometimes in certain situations for dependents. For example, H-4s are dependents of H-1Bs. Sometimes they're eligible for an EAD, and that's true of other visa classifications as well. The EADs can also be granted to people who are here on TPS, temporary protective status, DACA, asylum, and we've seen all kinds of changes in the EAD validity and related rules. So if you are at all involved in I-9 compliance, you know that or in other situations, and maybe other situations, other reasons that but there have been so many changes with TPS, with the ending of TPS. So I have certain corporate clients that hire foreign nationals, they don't necessarily sponsor them, but they hire foreign nationals who are here on TPS, asylum, DACA, any number of other classifications. And there have been a lot of questions about I-9 compliance. Is this EAD actually valid? Because it's expired on its face. What is the rule today? And I, as an immigration lawyer, I do this every single day, day in and day out, have to actually look it up, because it literally changes overnight, because there are sudden changes in the law, because there's ongoing litigation and there might be a court order. So it's become very complicated to keep track of that, but essential, because it's essential for compliance. The other change that we've seen with the EAD is the maximum validity period for certain EAD classifications. So again, for EADs, for work permits, you can have a work permit based on any number of underlying statuses or reasons to have a work permit. For some classifications of work permits, not all, but for some classifications, the validity of the work permit has now gone from sometimes 5 years. It previously was valid for 5 years. Now it will be valid for 18 months. And that applies to work permits where the application was pending or filed after December 5th of this year. That's a huge change. So we're going from a validity period of longer, potentially 5 months, down to 18 months. And the processing times for EADs are long. I think I saw a statistic recently when I was preparing for this that something like 900,000, that is almost 1 million EADs, have taken over 6 months to be processed recently. And I don't remember where I saw that statistic, but it was on a government website. So that's huge. That's a huge, huge problem. And it means that, or potential challenge. And it means that if you are working using a work permit, you absolutely have to stay on top of that. You have to make sure that you're applying for the work permit as soon as you can, the extension or the renewal as soon as you can, and that you're in contact with your immigration lawyer to make sure that you're doing everything you can to avoid a gap in employment. And despite your best efforts and your lawyer's best efforts, that may still happen, unfortunately. In addition, there has been a 540-day long automatic extension, again, for certain types of employment authorization documents or work permits. October 30th of this year, an interim final rule was published that did away with that 540-day. It happened literally overnight. We got the notice that this was happening on October 29th, October 30th, it became effective. And that in our practice affects the work permits that are tied to an adjustment of status filing, which is a green card filing, and H-4 EADs. So also not a great change that we've seen. We saw student visa revocations earlier this year. You may remember seeing that in the news, all kinds of information, all kinds of headlines about student visa revocations. Pretty widespread, hundreds, if not more, of student visa revocations. And we're seeing something similar now. It's called prudential visa revocations. We're seeing that with H-1Bs. It can happen with other visa classifications as well, but we're seeing that happen. The reason I mentioned the student visa revocations is A, it happened this past year, so it was a change, something we haven't seen before. B, it's something that happened, and I'm not mitigating the severity of what happened. I'm not saying that it's okay. I'm not saying, oh, if that happened to you, then too bad, so sad, get over it. I'm not saying that. What I am saying is that in some instances, not all, but in some instances, the situation ended up being okay. They were reinstated, they were able to sue. And of course, that's a huge, huge, very stressful event, very expensive, life-changing event for sure. But what I'm saying is, the reason I mention this is when we see a headline relating to immigration law, really any number of other things, but when we see a headline relating to immigration law, remember that the headlines that you see, whether it is in a news outlet, even if it's a reputable news outlet, or on social media, or friends, just talking to friends, neighbors, colleagues, whoever it is, the information that, like the hook, the information that we as humans find most interesting, sadly, is information that's really scary, right? So if there was a headline that said, for example, prevailing wages are taking 5 months now instead of 6 months, nobody cares. Nobody's going to pay attention to that. But if you see a headline about visa revocations, about denaturalization, about any number, the H-1B $100,000 fee that we'll talk about in a minute, you think, oh my goodness, this is terrible, this is awful, this is the end of US immigration. And it is awful and it is terrible and it does have tremendous negative impacts on a large number of people. I'm not mitigating that. I am saying that it may not be as bad as it sounds when you first see that headline. And that's a great transition to our next topic here. We're going to talk about travel, and the first thing we're talking about here is the $100,000 fee, which dropped in September. So remember, first way that we heard about it as immigration law professionals is the headlines. I saw an article, or actually my colleague did, in CBS that said Trump is implementing $100,000 H-1B fee. So you think about that and you think, or you see that and you think, oh my goodness, now every single person on H-1B, we didn't have any information, is going to have to pay $100,000. That's the end of the program. What's happening? It is bad, for sure. It is not a good situation, but over the period of a month, we did have to wait that long. We got additional information, and the administration is saying, and also, by the way, there's litigation about this happening. So hopefully we'll have some good news there sooner rather than later. But over the course of a month, we found out, oh, it actually applies. And again, I'm not mitigating the effect on the people and employers that this affects, but it only applies to certain individuals, certainly not to everyone who holds H-1B status, not even to people who hold H-1B status, or not only to everyone who holds H-1B status and is traveling outside of the United States. It only affects petitions that were filed after September 21st, 2025. It only affects individuals who are needing to apply for the H-1B visa outside of the United States. There's some other requirements in place as well, some other clarifications. And we have a separate video on that you can check out if you're interested. But my point is that the $100,000 fee sounds terrible. And like I said, it is absolutely for a lot of people. And also, it does not affect every single person in the United States in H-1B status or their employer. In addition to that, in terms of travel, and I put that under travel because it does affect individuals either who are applying for an H-1B visa from overseas. So if you're applying for the first time for an H-1B, we have clients who have recruited from overseas and that's on hold for now. Or if you went back home to visit for whatever reason and you're applying for an H-1B transfer, change of employer, the fee may apply then. Anyway, that's the reason I put that under travel. So in addition, for travel, no more Dropbox interviews. So previously, for the past several years, when a person has needed to go overseas to apply for a visa, and remember, you can't apply for a visa here in the United States. You can file a petition, but you cannot apply for a visa to be stamped in your passport here in the United States. So for the past several years, a Dropbox interview or a Dropbox application rather has been permitted in a lot of situations, not for all situations, but there were certain criteria you had to meet and you could apply for a new visa or extend your visa overseas without having to go talk to someone at the consulate, which was a nice benefit if you're going to have to apply for a new visa. That has been eliminated and now an interview is required. In addition, the Department of State has announced expanded vetting and screening. First, they announced that earlier this year for the F1, J1 and M visa classification. So F1 is a student visa classification, M is similar for vocational students, and then J is used for all different purposes. Anyway, it was announced earlier this year for those classifications. Now that is being expanded to the H1B and H4 classifications. So they say that they are doing more expansive vetting and screening, including looking at applicants' social media profiles. The result of this is that it is taking longer to have, and I think this will continue probably it's taking longer to have a visa interview scheduled. The availability is less because the consular officers are having to do this additional work. We're seeing an increase, or I think there's the potential to see an increase in 221Gs, which is a refusal. It doesn't necessarily mean your visa is outright denied, but they're asking for additional information or may put the processing on hold to be able to do their additional screening and vetting. Related to that, not directly related, but related to that, we're seeing in general that individuals who travel overseas and apply for a visa are increasingly likely to have a 221G notice because of something in their past relating to either a criminal charge that perhaps they thought wasn't that big of a deal, but hasn't been resolved, or because of a previous immigration situation that, again, they thought hasn't been a problem before. And perhaps the applicant thought wasn't that big of a deal, and it is a problem, and they're getting a 221G because of that. We're assisting a couple of clients right now with that type of situation where they have applied for a new visa for the past 16 years, for example, without a problem, and now they're having a problem. So just because you didn't have a problem before does not mean you will not have a problem now, unfortunately. And then, of course, we saw the travel ban that was rolled out earlier this year for the 12 countries, and then a partial ban for the additional 7 countries. In addition, we're moving on now to green cards. For that travel ban, this isn't necessarily a travel ban, but recently the administration announced that there is a, quote, pause on applications for certain immigration or applications for immigration benefits for individuals from a list of 19 countries of concern. And I'm using that in quotes. That's the administration's word for 19 countries of concern. So it's those 12 countries plus the additional 7 that have the partial travel ban. So we're seeing now in our practice that for those cases, for individuals that are from those cases, even if you are a dual citizen, so we have a client who is a citizen of one of those countries and a citizen of another country that's not part of those 19, and the oath ceremony has been canceled. So we are seeing that oath ceremonies are being canceled because of this. Other colleagues are seeing the cases aren't moving forward because of this. It seems right now that you still are able to file these applications, even if you are a citizen of one of these 19 affected countries, but there's not forward movement. They're not making decisions on these cases, including oath ceremonies being canceled. So it's not a good situation. But like I said, as of right now, you can at least still file, which is potentially a benefit. In terms of other things we've seen in terms of green card, there was some forward movement in the visa bulletin in October, which is Small glimmer of hope, not tremendous movement, but we did have some clients who were able to file for a green card, to submit the I-45 who were not previously able to do so. And the PERM labor certification process is moving along. Not at record speed by any means, but we're just excited. You have to embrace what you can, right? The glimmers of hope that you can. We're excited that after the government was closed the month of October, that first of all, mysteriously, the Department of Labor, so the Department of Labor was closed because the government was closed. USCIS is fee funded, so they were open even when the government shutdown happened. And then October 31st, I remember I was handing out candy Halloween night, and we get a notice that the Department of Labor is reopening, even though the government had not yet reopened. So I'll take it. But we're excited. We were excited to see, after the government reopened, we were able to file things, and now PERMs are being certified that we had filed many months ago. We're looking at like 16 to 17 months ago, but they are being certified. So we're excited for that. So looking forward into 2026, what can we expect, and what can we as employers of foreign nationals, people who support foreign nationals and foreign nationals yourselves, what can you do to prepare? I think number one, it's important to just keep in mind, not everything is as bad as it seems. And the way it is right now is not always the way it will be, for better or for worse, right? It could be better or worse going forward, but that's something I tell myself regularly, not just about immigration law, but any number of things. So grounded presence, I think, is healthy here. So I think in 2026, we can expect continued uncertainty and anxiety, certainly understandable, but that does not mean that we can't do anything. It doesn't mean we shouldn't be filing. It doesn't mean we shouldn't be taking action. So I think if you are going to file, and there are lots and lots of situations where I think it is beneficial for an employer or individual, family, whatever it is, to go ahead and move forward with filings. I think many situations it's beneficial to do that. And there's, we can talk through the risks if you have questions about that. But sometimes, honestly, and I tell clients this all the time, sometimes I think there's a bigger risk in not filing now than in filing now. So in other words, waiting, I think, is a bigger risk sometimes than actually taking action. So I think we can expect more uncertainty, more back and forth, certainly more litigation over the administration's policies that they're trying to implement. So in 2026, I would say travel with caution. If you are a foreign national or if you employ foreign nationals, know the risks that you're taking. And I have a recent video here on this channel about the risks in traveling and things you need to be thinking about. But right now, especially, I think more so than any other time this year, know the risks in traveling. If you're from a travel ban country, absolutely not. You're not going to be able to come back in, at least right now. Even if you are not from one of the affected countries, think about the risk. And I know there are things that a person may need to travel for, whether it is a family emergency, a family celebration. I know you have to balance personal and professional considerations against immigration risks, but really think carefully through traveling. Have an immigration sponsorship plan. If you're an employer and you hire foreign nationals or are thinking of doing that, have a sponsorship plan. Think through what type of position you're willing to sponsor, when you might implement those sponsorships, when you might begin the process, whether it's an employment-based green card process, or a visa classification process. Think ahead about how much time you might need. If you don't know the answer to that, that's why we're here, and we're happy to help you think through that and come up with a timeline. If you are an employer, honestly, even if you don't have foreign nationals on your payroll, I would have a regular interval, set up a regular interval for audits, for I-9 audits. Certainly, if you hire foreign nationals, audit those public access files. If you hire individuals on H-1B, E3, or another visa classification, H-1B1, that requires the public access file, make sure that your paperwork is in order. It doesn't mean you need to lose sleep over it, but I do recommend you set up regular intervals for audits to make sure that all of your paperwork is in line. If you hire foreign nationals, plan, or maybe even if you don't, plan for site visits. Have a written policy in place for site visits so it's very clear. When I say site visits, I mean visits from individuals from the government. It can be from any number of different agencies, but have a plan in place for who they need to talk to, what that person is going to say, who that person is going to direct them to, that type of thing. This is not the time for to not have a plan and to just have individuals well-meaning, but give information that is not appropriate to share with government officials. There's some information you have to share, there's some that you don't. And you want to make sure the information you're giving is accurate and is actually needed. So you want to have a written plan in place and make sure that everyone is trained on that. And then my last tip as we finish out 2025 and head into 2026 is to keep calm and carry on. And I know that's easy for me to say as somebody who I personally do not have to go through the immigration process. I do not have loved ones. When my family has been here for, I do have loved ones, but it has to go through the immigration process. My family's been here a really long time. So I personally don't know what it's like. I do know vicariously through my clients, and I care about every single one of our clients, their families, their employers. I know it's a really stressful time. So I'm not saying, oh, it's totally fine. Don't worry about it. There's just a few changes going on. That's not what I'm saying. I am saying keep calm. That I think the number one thing that we can do to, maybe the word fight isn't the best word for this, but the number one thing that we can do to go through this process with grace and as much ease as we can is to keep calm and stay educated and know what our options are. So I hope that you have found this information helpful. If so, I hope that you will share this video with a family member or a friend, subscribe to our channel so you don't miss our next video, and put any questions that you have in the comments. I can't give legal advice here, but I'm happy to answer general legal questions or general questions as much as I can. We are here to help. If you need help with a family-based or employment-based immigration matter, we are here to help. We would love for you to be our next client. We will have information on how to contact us and set up a consultation on our outro slide, and we look forward to hearing from you. Our next and final video for 2025 for the go live, or for the live at lunch rather, will be next week. It will be pre-recorded and it will be the same type of format, but about family-based immigration processing. My name is Emily Sumner with Sumner Immigration Law. Until next time.